This video is about out-slicking the slicksters and beating them at their own game. The lawyers opened Pandora's box when they broadened the term person to include an entity of fiction. At one time, the word person only pertained to a living soul, man or woman. Now it also means corporation, association. The Commonwealth of Pennsylvania is a person. The local water authority, if it's incorporated, is a person, and so on. And that's going to bite them. So it's time we're going to crash their party. Said beat them at their own game. Okay, usual routine is that the operator of a vehicle, if you get pulled over, you're the operator. No matter what happens, they're going to name you as the defendant. If you were speeding, failed to use your turn signals, whatever, caused an accident, or an equipment violation. Say in Pennsylvania you need an inspection sticker, so if the sticker was expired or the registration was expired, they're going to list you as the defendant. And I'll show you how you can put a motion to dismiss, because that's the wrong party has been named as the defendant. Okay, what you're looking at is the top portion of two documents. The first, in green, this was issued by the Department of Revenue up until 1969. In 1970, the Department of Transportation was created, and the Pennsylvania Department of Transportation is a subsidiary of the Federal Department of Transportation. It has no real affiliation with the Commonwealth. I'll explain that later. Now we have a Bureau of Motor Vehicles. The Bureau of Motor Vehicles was created in 1905, and it was first as a sub-entity of the State Highway Department, and then it was transferred over to the Department of Revenue, and then after 1970 it became a sub-entity of the Department of Transportation. Okay, but if you take notice that at one time it said a certificate of title to a motor vehicle, and now it says a certificate of title for a vehicle. For replaced to, and the word motor was removed. That was a game changer. Now, people assume that anytime they see the word vehicle, they're talking about a mechanical device that's like parked in their front yard or in front of the house. When the word vehicle is used on a certificate of title, it's not pertaining to a mechanical device, because that word has been bastardized. A certificate of title is a commercial instrument, and therefore it is a commercial vessel, and its cargo is information. And the cargo that it's carrying is that the name of a vehicle, starting officially in 1972, was registered as a person. And it's no coincidence that starting in 1969, the VIN plate, as you might comprehend what it means, was taken out of hiding and repositioned on the outside of the vehicle, seen through the bottom of the windshield. Because the vehicle's name is publicly displayed, such as Ford Escort or Cadillac Escalade, where Ford would be the surname and so would Cadillac be the surname. So not only was the vehicle's name identified, publicly displayed on the outside of the vehicle, but so was its number. This was to comply with the new international banking regulations that took effect in about 72. So now, a vehicle is not registered as a mechanical device. That's why they had to get rid of the word motor. And now it's registered as a person. And you, when you sign the registration credential, you are the authorized agent of that name, the vehicle's name, and any actions brought against it. So in this case, if the vehicle had the inspection sticker was expired or the plate was expired, the vehicle is in violation, not you as the operator or not you as the registered owner. So that therefore the vehicle has to be named as a defendant. If this is proven correct, this is going to crash their whole system. I mean, this is going to send shockwaves throughout the whole country. And good for them. This scam, this money racket has to stop. I mean, all these lawyers, they all belong to the Millionaires Club. They're stuffing their pockets. Now, what's going to be a hard pill to swallow is that starting in 1919, all vehicles became federal property from cradle to grave. The only thing you're allowed to own is liability. Well, liability by itself is an abstract thought. So we need something tangible. I mean, if we're going to trade or transfer liability, so we need a document. And there comes the certificate of title. Now, after the initial point of sale, and after a new car leaves the impound yard, it's taken out of quarantine, the only thing you own is the liability. And the only tangible thing you could own is this piece of paper, the certificate of title. And since all vehicles remain federal property, the only thing you could buy, sell, or trade is the document, as far as being something tangible. That's it. So we have to break the spell, the illusion of ownership. You might have to go see a therapist when you get done watching this video. And you have time to think. You have to think for yourself. I don't tell anybody to take what I say as face value. Go check it out yourself. I spent 6 years doing this. Okay. The vehicle code is infested with contaminated language, bastardized. Take the phrase vehicle registration. No mechanical device is ever registered. It's information that contained in documents that is registered when it's copied from one venue to the next. So the phrase should actually be vehicle document registration. Mention again, the lawyers opened up Pandora's box when they broadened the term person to now include an entity of fiction, such as like the Commonwealth of Pennsylvania. It's a person. And now, speaking of being an owner, you see here it says first lien favor of. I don't know if it's hard to tell, but there's a colon here. You know, they have all this fancy scribble in the background, but there's a colon there. That colon links to the to People's First National Bank. Well, with the colon, People's First National Bank, its function is identified as the first lien holder. That colon is important. On the other side of the document, you have second lien favor of. It's hard to see, but there is a colon there. Most of the time, there's only one lien holder. Continuing. Here, it says lien date. There's a colon. So if there's a date put here, well, what is the date? What's its function? So with the colon, that date is identified as a lien date. But however, look at here where it says registered owner. There's no colon. That's not harmless error. That was deliberate. Now, it just so happens that your name is printed in close proximity to this phrase registered owner, but that doesn't mean anything. It's not linked. There's no colon. Now, people get blinders. They see that word. Oh, they don't even see the word registered. They zoom in on the word owner. Oh, look at that. Owner. I own the car. Nah. What's the difference between a nurse and a registered nurse? A registered nurse is one who is issued a license. This phrase, registered owner, is a covert name that means tenant. And I'm going to show you why. It's these lawyers, it's all this deceptive, these code, it's all this like secret language that only they know about. Okay. See what it says? Joint tenants? Now, using polar logic, that means you could have a single tenant, one. So that's what you are. The phrase registered owner is a covert name for the word tenant. If you go to section 102 of the vehicle code, there is no definition for a registered owner. There's no definition for a certificate of inspection. There's no definition for a certificate of title. I mean, these are important words, important terms. No definition. They were omitted deliberately. Now, section 102 has an archaic word, owner. But an owner and a registered owner are two different critters. And the word owner in section 102 was amended to mean someone that has property rights. Well, if you're a tenant, you have property rights. Now, property rights are divided into two halves. You have benefit and liability. So as a tenant, you have the benefit to occupy the structure. As the tenant of the vehicle, you have the benefit of sitting inside it. And then comes, you can't have benefit without the liability. Now, as a tenant, if you leased an apartment or condo, well, your liability is limited. I mean, as a tenant, you're not responsible to repair the roof or fix the cracked foundation unless you agree. But here with the Commonwealth, without your consent and without disclosure, they thrust full liability on you. That means if you're going down a road and the Commonwealth is negligent, they don't take care of the roads, you hit a pothole, you lose control, you blow out a tire, you get in an accident, the Commonwealth cannot be listed as a co-defendant because you've agreed to take on all liability. This is one reason why they don't care about the roads, because they're not liable. You are, and every other motorist. It's time we stop being dumb and stupid. What else can I show you here? Now, let's get back to this picture here. Stay focused on this picture. Well, as long as my camera doesn't act up, it's acting up again. Anyway, there's an old saying that registration is confiscation by proxy. That is so true. Registration started in the Commonwealth in 1903 by Act number 202 of 1903. That's what got the ball rolling. And Act number 202 of 1903 is the smoking gun. It was a handle poker, a bluff. And I'm going to devote another video to that. And it's been a legacy of theft. For the first 2 years, registration was handled at the county level. You had to go see the local profanatory, the courthouse. And they tricked you into having the car listed as a county asset. And then your vehicle and all the others registered in the county were used as collateral to acquire bonds to fix the roads. I mean, in 1903, most of the roads were dirt. And the politicians, they did not want to raise general taxes to meet this new demand. We had the panic of 1901. They were still suffering from that. Plus, you want to talk about raising taxes, that's not good in an election year. So they felt that if the motorists wanted better roads, then they're going to pay for them one way or another. So they used some shady tactics. So actually, the idea of a vehicle as private property ended in 1903. But it was slow at first. The first 2 years, that was the beta test to get everybody accustomed to this new procedure of registration. And at the time, for the first 2 years, it was the county banks, the local banks that were benefiting. Now, back then, you didn't have the big corporate, international corporate banks as you do today. They were forced out of business during the crash of '29. But back then, it was the local banks owned by the local merchants that were loaning money to the county. Well, then, in 1905, I guess Harrisburg seen the profit potential here. And then they created the State Highway Department. They centralized registration. And then from 1905 to 1918, all vehicles were state property. And how that came about is ingenious in its simplicity. I'll explain that in a separate video. So that means that the word, so in 1905, when the State Highway Department was created, they created this new bureau called the Bureau of Motor Vehicles. And prior to 1905, the word motor vehicle had a hyphen in between it. But then the hyphen was removed. So you had two separate words. Well, the word motor vehicle became a covert name for state property. It was like a secret code that only the insiders knew. The Commonwealth has bestowed upon itself no affirmative duty to make disclosure. This is why a lot of stuff is missing off in forms. But an agent of the state has an affirmative duty to articulate intent, or otherwise he can be deemed incompetent. Because how can you enforce the law if you don't know it? Okay, continuing. So now, I said from 1905 to 1918, all vehicles were state property, and then 1919 comes rolling around. Well, the war, World War I, the so-called Great War, was expensive. Now, the federal government wanted to pay its war debts, so it figured out a way, by the use of the National Motor Vehicle Theft Act. The excuse given that there was too many stolen vehicles crossing state lines with forged paperwork. Trafficking, piracy, so that the roads were brought under Admiralty Maritime jurisdiction. 1919, the roads were classified as hostile inland waterways. That allowed the federal government to raid the Commonwealth's cookie jar and confiscate state property to pay war debt. But Uncle Sam's still hungry, still needs a lot more money. So that means starting in 1919, cars are still being made, still being, sold. So starting in 1919, now the federal government was stealing public property to pay war debt. Now, it couldn't come out of the closet and announce this. It needed the cooperation of the boys in Detroit to devise a marketing strategy to sell the illusion of ownership because they had a vested monetary interest. You talk about a conspiracy theory. That's for you to decide. This is no theory. This is what happened. Well, I should say I'm alleging this is what happened. Continuing. Well, from 1919 to the present, all vehicles are federal property from cradle to grave. So to hide this theft that took place, they had to bastardize the terminology. I mean, I'm going to have a separate video on to explain how all the language was bastardized. Take the word passenger. The word passenger literally means one who pays for passage. So that means a bus or a taxi has passengers, because passenger is cargo. Anybody in your family vehicle is an occupant, is a co-traveler. But the word driver has been bastardized. It means opposites. The driver, it literally means a commercial operator. So everybody is a driver. I mean, the government was desperate to distort the language where the gasoline in your gas tank was classified as freight. So therefore, any vehicle carrying such freight was a commercial vehicle. I mean, they were really stretching the imagination here, coming up with any angle. So getting back to we're going to have a court hearing. You walk in the court, the first thing you do, motion, okay, there's several motions to dismiss. If the, I said in the other video, you don't just let the officer appear on his own, you subpoena him. So he becomes your witness and you can challenge his competency. But you look around, if an agent from the Attorney General's office or local district attorney's office is not there to represent the Commonwealth, motion to dismiss. The plaintiff or representative did not make appearance. Case dismissed. Now, most magistrates, they're pretty cocky because they've been getting away with it for so long. And the magistrate's hearing is not a court of records, so he doesn't care anyway. Because he can, but there's a way to force his hand that he has to make the right decision. I'll explain that in a different video too. Okay, so one motion is, okay, the plaintiff or legal representative did not show default. You move for summary judgment in your favor. Then you could also put a motion to dismiss that the wrong plaintiff was named as a party to the action. Well, here with this, the vehicle was found in violation. Its registration or its license plate was expired, or the didn't have insurance. Now, if you borrowed my car, you're an operator, and you get pulled over, and the police officer finds that my insurance was expired. That shouldn't be on you, especially if there was no accident. Well, when in 1972, when a vehicle was registered as a person, that allowed the insurance companies to give a policy in that vehicle's name. You don't get driver's insurance, you get auto insurance. The automobile bill has to be covered, not you. Said if there was a violation against the vehicle in some way, well, then the vehicle has to be named as a defendant, and then the registered owner would have to come in as the authorized agent on behalf of the named defendant. Well, then because most of the time the registered owner is the operator or a member of his family. There's so much that could be discussed. I'm trying to keep this video, under about the 30-minute limit. Can't stress enough that the lawyers opened Pandora's box when they broadened the term person to include an entity of fiction. A thing of accepted make-believe. So now how would a lawyer explain away, well, why did they replace the 2 with 4, and why did they remove the word motor and have a vehicle? I learned a long time ago that anytime a lawyer starts speaking, be wary, because what spews out of their mouth is a bastardized form of language known as legalese. To me, they're word pimps. They've lost the ability to talk normal. In one of my other videos, I mentioned that here, even the police have lost the ability to talk normal. The police, they don't describe being on stakeout hiding the bushes. Oh, we have to use a fancy term. We're in stationary patrol. That's an oxymoron. You can't be moving and standing still at the same time. So that means the phrase stationary patrol is bastardized. Because it means, are you moving or standing still? Make up your mind. Just like the word shall. Is it permission or mandatory? Which one? So to reform this whole system, we have to establish a dictionary and clarify the terms. For example, the word passenger only pertains to one who pays for passage, that is in a taxi or bus or train. For example, they pull up to your vehicle, they ask you for your driver's license. You got a taste? Hey, officer, I says, listen, I got to clarify something. I don't care what it says on that license. I'm not I'm not engaged in commerce. I'm just an operator. See, all the default settings are set to a commercial status or to the officer's benefit. He's allowed, when he comes up to your vehicle, he's allowed to assume that you are engaged in commerce and therefore anybody in the vehicle is a passenger. That's the default setting. Commerce. Well, you got to tell him, no. That's my girlfriend in the car. She's just an occupant. She's not a passenger. Okay. That's for another day, but I'm trying to make sure that I mentioned everything I want to mention today. Oh, this thing about this propaganda that you have to be a licensed attorney to practice law. Yeah, you have to be a club-carrying, dues-paying members of the Millionaires Club before you could, represent a client. Well, A police officer is not a member of the bar, but oh, they let him slide because he's a friend of the court. So a police officer is allowed to act as an attorney and prosecute the case on behalf of the Commonwealth because they made an exemption for him. A lot of these police officers, besides they need to go on a diet, they can't even spell. I mean, a lot of them are marginally educated. And then they're going to, oh, but they're a friend of the court. But yet, if you got in trouble and you wanted me to come in and assist you as counsel, they could say, oh, no, no, you can't do that. You're not an attorney. Okay, stop and think about it. Is when, if say you got caught for something simple, like you didn't use your turn signal. Well, the officer can't cite you as a man or a woman, a living soul. They put your name on a piece of paper. And then you're the authorized agent of the name, so you are the counsel for the name that's cited on that's on the citation. So you're acting as counsel. And the same with if the vehicle was named as a defendant, you're the authorized agent, so you are allowed to act as counsel on behalf of that person, the vehicle person. They come up with this propaganda because they want to protect their racket. It's just a money game. And besides, this thing about practicing law, it only pertains if the courtroom is a ship and dry dock. I explained that in a different video. But if our feet are on land, they could take a hike with that bullshit story. It's your choice. If you feel that a friend is competent enough to represent you, can articulate, say you're a little bashful and shy, you can't speak too good in front of people, whatever. So if you have a friend that could speak on your behalf, I mean, you could always nudge him, say, don't say this or don't say that. I mean, you still have a say in the matter. Why not? Because they want to protect the money racket. I almost forgot this part. Now, concerning that phrase, the registered owner, we have to look at the verity statement that's on the title. Now, at one time, this verity statement was quite large. It took up almost half of the face of the document. Now it's down to one sentence. So I'll read what it says here. It's well, that pertains to the Secretary of Transportation, certify as of the date of issue, the official records of the Pennsylvania Department of Transportation reflect that the person or persons or company named herein is the lawful owner of the said vehicle. That says a lot of nothing. I want to focus on the word person, or plural. Well, if more than one person can own the vehicle, then where it says is the lawful owner, it should be is/are. And then owner should have the word S in parentheses. This is indicating to me that there's only one owner. And when you boil it all down, and it's not you. The word vehicle, it does not pertain to the mechanical device. The said vehicle is a name registered, is a person. The said vehicle is a person, not a mechanical device. Okay. Persons. How many persons are identified on a certificate of title? Well, here we have one is the Pennsylvania Department of Transportation. That's one. Two is the name of the Secretary of Transportation. His name is printed. That's two. What else? Here we have the Commonwealth of Pennsylvania, but you got to be careful. See, the Commonwealth of Pennsylvania is in a box. That means it's excluded from the document. You have to understand the four corners rule. Whatever in the box, it's like it's not even on the document, but still going to count that as a person. So that's three. Then you have the Department of Transportation. Now that isn't clarified. So the Department of Transportation here that's talking about the Federal Department of Transportation, whereby the Pennsylvania Department of Transportation is the district trustee or subsidiary. So that means we have the Commonwealth of Pennsylvania, the Department of Transportation, the Pennsylvania Department of Transportation. We have the Secretary of Transportation, that's 4, and you're number 5. So there's 4 names, there's 4 persons listed on that certificate, on a blank certificate, before they even would put your name on. So which person are they talking about? Can't be you, because like I said, your name is only in close proximity to that phrase, registered owner. There's no colon. It's this phrase, registered owner, and your name, they're not linked. They just happen to be on the same document in close proximity. Now, said these documents, I mean, people think that certificate of title is a foundation stone to them. I mean, this might shatter some people's whole sense of security. That they end up with a bogus document, they can wipe their ass with it. Well, anyway, sorry for the vulgarity. When it comes to hearsay, now when an officer files paperwork with the court, now technically I guess the magistrate is not allowed to look at it until like the day of court. So what he's looking at is hearsay. Anything written on there. This is why the officer has to make an appearance and claim and say, nope, I'm the one who wrote that. That's why he has to make an appearance. This is why you have to subpoena him, and then he's your witness. You can challenge his competence, because if he's incompetent, then he's not allowed to sign any he signs the citation, and his signature means nothing. If he's deemed incompetent, then he's not authorized to issue a citation. Now I got to talk about the recall of 1919. Prior, like I said, the certificate of title was created in 1905, and for the next 13 years they were issued by the Commonwealth under its direct authority. Federal government intervenes, supersedes, takes over, it's like a hostile takeover, takes over vehicle registration, and invalidates the certificates of title issued by the Commonwealth. Now they're validated, so there's a recall. So you have to, back then the motorists had to surrender them, and then new documents were issued. After 1919, all certificates of title are federal documents because they're governed by federal regulations handed out by the district trustee, which after 1970 is the Pennsylvania Department of Transportation. And just like the word Pennsylvania, for example, there's nothing federal about the Federal Reserve. The Federal Reserve is the name of a private corporation. It's my allegation that the Department of Transportation is a private corporation. That's for another video. So, when not only did the federal government invalidate all the titles that were issued by the Commonwealth under the Commonwealth's strict authority, but it also invalidated the Commonwealth's vehicle code. It was done away with, and there's evidence to that. So after 1919, the Commonwealth was downgraded to the role of district trustee of federal property, and it's only authorized to promulgate policy on how it's going to implement federal regulations. For today, the Commonwealth can enforce the use of seat belts because the federal government mandated their installation. So the Commonwealth could determine how the seatbelt law is enforced because, like I said, the federal government mandated their installation. The reason why the federal government can mandate the installation of seatbelts in vehicles because they own them. Federal government owns the vehicles as property. And then you as the tenant, and just for example, if I own an apartment building, I could tell my tenants, well, you're not allowed pets, no smoking. And same thing with the federal government's doing. They own the vehicle, so then they could tell you as a tenant what you could do inside. That's about it. Till next video.